your testimony at the hearing is one of the most important things you'll do in the appeals process. The referee will use documents and other evidence to make a decision, but your testimony will need to fill in any gaps and clarify exactly what happened with your employment or whatever issues are involved. At the hearing, the referee will put you under oath under penalty of perjury before you testify, so make sure you do your very best to tell the truth. If you honestly don't know the answer to a question, then don't guess. It's okay to say, "I don't know." Be sure to listen carefully to the question and to answer the question directly rather than evading it or going off on tangents. Stay focused, and if needed, take your time. Also, don't exaggerate when you answer a question, and answer the question and nothing more. Referees often get upset when a witness gives a really long answer or talks about things not related to the question. That said, if the referee is cutting you off, which can happen, and you think the information you want to provide is vital to your case, then you can say something like, "I understand you don't want me to talk about this, but you said this is my only opportunity to give testimony, and I think this is really important to my case." I want to insert an important point here. Some referees can be very strict, and they may even be rude to some claimants. I like to assume it's just because they have stressful jobs and are making difficult decisions. But this is your only chance to make the best case for your eligibility, so stand your ground if needed to make sure you get your evidence into the record and the important points of your testimony heard. Continue to be respectful and kind to the referee and the employer while also being assertive and persistent. If for some reason you aren't able to say what you need to say during your testimony, then another option is to include it as part of your closing statement if you don't have an attorney giving the closing statement for you. Your closing statement will still be part of the record, so you might be able to refer to it on additional appeals if needed. So just a few other tips. As you give testimony, be confident, positive, calm, and natural. Don't get upset, raise your voice, or argue with the referee or the employer's attorney or representative, because this will make you sound unprofessional. Speak loudly and clearly, and if your hearing is in person, present yourself well by wearing nice, clean clothes. Don't chew gum or joke around. Be serious while also relaxed, friendly, and courteous. My philosophy is that you're much more likely to win someone over to your point of view by treating them kindly and with respect rather than the opposite. When the other side is cross-examining you, continue to be respectful. Only provide information that responds to the specific question they ask you. You don't want to give the other side any new information they might use against you. On the other hand, if you feel you need to clarify something important, then go ahead and do it unless the opposing attorney or referee says not to. In the end, all you can do for your testimony is tell the truth while trying to provide the information you believe supports your case and hope it's enough to win.